This is it, what could be decision day at Harris County Criminal Justice Center. Closing arguments in the murder trial of AJ Armstrong will get underway in about 90 minutes. And then it will be up to the jury. Did AJ shoot and kill his parents in cold blood while they slept? 7 years, 3 trials, now 12 people are charged with trying to do what 2 juries before them couldn't: reach a unanimous verdict. It's a big day for the bench.
Good morning, good morning. This is what we've been training for. This, we expect, will go to the jury today, the 3rd trial in the AJ Armstrong murder case. This is 7 years in the making. In a sense, this is the day we've been training for, guys. And we've been pretty much on Judge Kelly Johnson's schedule, I would say, right? Yep. Didn't she anticipate it going to the jury this week? We expect to hear closing arguments from each side. That'll start just this morning.
At 9:30 is when it's scheduled, and so today is the day when the rubber hits the road. They have to lay it all on the table this morning.
So who goes first? What's sort of the process?
So what happens is the state will have the opportunity to go first. They're going to lay out their roadmap as to how they believe they proved the case, Joel. And then what happens is the defense will come up. Now, the key to this is that because the prosecution has the burden, they get the last word. And so after the defense gives their closing argument, then the state will be able to come back and try to punch holes in everything that the defense says, and then the jury goes to deliberate off of the last words of the prosecutor. We
have the benefit, Rowan, of having heard or gone through this 2 times previously, 2019 and 2022. Those were the first and second trials for AJ Armstrong, which ended in hung juries. One time it was 8-4 in favor of conviction. The other time it was 4-8. That's where we are. So I'm asking you guys to look into your crystal ball. And my question to you, Ms. Defense Attorney, is has the state proven its case, do you think? And what are they going to really hit in those closing arguments?
Here's the thing, Joel. You can't answer that question if you're not in that deliberation.
Really?
It's just not a question we can answer, because there are so many factors and dynamics that go into jury deliberation. I'm not sure if you've ever seen the movie 12 Angry Men.
I have. I've seen the original.
Okay, so it was one juror who changed everyone else's mind.
True.
So you can't say, if juries are so fickle, what will be the verdict? Not from out here. Yeah. But I can tell you this. It is going to be a deliberation that's going to take a little time. I promise you that.
Rowan, they're going to be sequestered during this process?
Possibly, likely so, that the judge the last 2 days it's told the jurors pack a bag. And yesterday I saw a number of them with their bags in tow as they were going to the jury room. And the judge again today told them, or last night that is, told them they could either leave their bags within the courts where it'd be locked up, or they can just bring it back with them again, with the expectations that they might be sequestered, put into a hotel room or wherever it may be until they can reach a verdict, or whenever they reach whatever decision they may reach at the end of all of this, or not reach. Good point there. And so this is a sequester, being held up until that decision's made. This was brought up during jury selection. Someone who doesn't make the ultimate jury brought this up. Would they be sequestered? And in this case, it seems all points likelihood that they will be.
We're talking about, they'll do the petit jury, which is the original 12, right? And now we have 3 alternates left. Will they be sequestered as well, do we think?
Yes, I believe so. Because if for any reason during the deliberation, one of the jurors from the deliberating jury gets sick, an emergency happens, that other juror has to step in. And so they want that same preservation over those alternate jurors as well, in terms of what they're hearing outside of what they heard during the trial.
When we talk about closing arguments, typically, I guess it would be on a case-by-case basis to some degree, but is this something that's like a 10-minute speech? Is this an hour long? What do we expect?
The judge said expect between 3 to 4 hours.
Oh, really?
She's told each side has up to an hour. If they go past it, but they're still kind of going in the swing, she won't let them them stop, she'll let them keep going. So we're expecting, and I expect all of these attorneys that we've gotten to know over the last few months to take every bit of that hour allotted to them.
It's kind of interesting, this setup, because it's kind of the same as in 2022. The first closing for the state's case is going to be given, I understand, by Ryan Trask. He did that in 2022 as well, right? And then for the defense side, Rick Detoto is going to take the reins. And we heard from both of them in 2022. We wanted to play just a little piece of sound from back then to see how each side sort of tackled the issue of the investigation and the competency of that investigation. Let's give a listen.
You're going to learn that the defendant was questioned that night. He was brought to the HPD homicide, and he waived his rights and he spoke with investigators about this case. And what you're going to learn is that the defendant has absolutely no emotion. And I want you to listen to it and put it in context that you have a 16-year-old who is being interviewed by 2 homicide detectives. He has absolutely no emotion. He does not care, or appears not to care, about the consideration of his parents. He doesn't even have questions for how all of this happened.
No gunshot residue on AJ. No blood on his clothes anywhere. No gunshot residue on his shirt, on his pants. No fingerprints on anything. The Houston Police Department, the evidence will show you, had full control of that scene. They could have done anything they wanted. No blood in AJ's room. No blood on any clothes anywhere. The sinks were bone dry. No one washed their hands. No physical evidence linking this young man to what happened.
I got you, Joel.
That was from trial number 2, and that's Rick Detoto, the lead defense attorney. Interesting, because maybe you would put an asterisk now on no blood evidence, although I'm not so sure about it, including the material that was suddenly found before the beginning of this trial on the backside of that name tag that AJ was issued. Do you think that's going to be a big factor? Is that blood evidence? Is it going to be in the jury's mind that there was some degree of blood on his clothing or on his person?
In my opinion, it still goes into the no blood evidence category. I mean, 3 years, guys, and we harp on this all the time, Joel, because it's just so significant that it took you 3 years from some outside person to come in.
She's from Montgomery County.
Right, she's not even from Houston.
Yeah.
She's from somewhere else. She comes in and she finds a flake of blood on the back of a sticker that was not transferred from his T-shirt that he had on.
Right.
So to me, that's still kind of questionable. I don't think that they're going to put any stock into that, jurors.
Let's talk about that briefly, because this became a whole thing coming into this term. This person at the top left corner there, redhead there, Sergeant Celestina Rossi with the Montgomery County Sheriff. She was brought in here to be as the expert, so to say, on this blood splatter. She went into deep detail on all these different terms about how she looks at blood splatter and residue and all this stuff. What comes importance is right here, this drawing here, where she's talking about expiration from the nose and mouth, talking about Antonio Armstrong Sr., that if he was shot in the way that they believe he was shot, that he would have had blood coming down his nose as he's trying to breathe, struggling to breathe, causing some of that blood to push onto possibly, if the prosecutors are arguing this, AJ's clothing. And she testified they are so small they couldn't be seen by the eyes. But then Detoto later came on with, he had a water squirt gun there, showing that, well, if this happened, there'd be a lot more blood beyond just that one spot that we saw on that shirt. And I got this shirt tossed over to us as a demonstration. There was a point where they brought in the original prosecutors, and this was a big sticking point. The original prosecutors from the 2019 trial proved and shown in court pictures of them handling the shirt without any gloves. One of them scrunches it up, and like right on here, and there's a part in the video where it appears it may have lifted the name tag. And so that's what the defense is really harping on now, saying in 2019 no gloves were worn while they were handling this material. And so he's suggesting, Detoto is, that the blood might have transferred over onto the name tag in that way.
Absolutely. They call that cross-contamination. You just can't believe it. I thought what Rick DeToto did was classic, and that he took that spray bottle and he says, okay, let's go with your theory, Rossi. Let's go with the theory that as he was breathing, blood was spouting out of his mouth onto AJ Armstrong. Then certainly you're going to tell me that with all of this spatter, and what people don't realize is that it's blood spatter, not splatter. There's no L. So you're going to tell me with all this blood spatter that all of these particles, one small particle got on the back of a sticker and not on his shirt. It's just not plausible.
It really isn't.
It's just not. And no one found it.
I know.
In 3 years.
I think
Stop
he
it.
successfully knocked down any sort of evidence that was on the sticker and or clothing or his person. We should, she was a witness for the prosecution.
She was probably one of the people longest on the stand here.
Can we talk about all of this, by the way, because this is a big difference from the previous two cases. We are talking serious props. What have we seen in the courtroom just, last week, this week?
Yeah.
What was in there?
Last week, as we can show on this drawing here, they brought in a makeshift bed, they brought in 2 adult-sized mannequins, and then stairs that they kind of put together in the courtroom to kind of show, which is a big point for the prosecutors, during the 911 call and police interview with AJ the night of, that he said that he saw an intruder, and that's where these stairs come into play here. As you can see, this is a drawing of John Jordan, the prosecutor, showing what it looked like if they were on the stairs, if AJ was on the stairs. He would have likely, they're alleging, seen more of this alleged perpetrator because the parents' bedroom is so close to the bottom of the stairwell. So I will say, in being in the courtroom there, that was the newest thing. They didn't do this in any previous trials at all.
Right.
With all this props and demonstration, I thought it resonated with the jurors. That you could see a lot of people just kind of like nodding in agreement, like it made sense to them when they brought this prop out. I've also heard from other attorneys saying that this was like them throwing a Hail Mary, just trying to see if something would stick and work. So we'll see if all time tells.
Well, it was fairly theatrical, wouldn't you say?
Absolutely.
Absolutely. They bought the theatrics this time. They really did. And partially because what I would do when I was a professor and I would teach trial advocacy, I would tell my students, when you are displaying what your trial is, you're laying that trial out, you want to pretend that your jurors are blind. You want to be able to recreate that moment so that they visualize it in their heads, not just with their eyes, but also in their imaginations. So because once you do that, then jurors now take themselves to the scene of the crime, of the incident, of whatever happened. So that's exactly what John Jordan did. He brought that moment to life.
You think
for the
effectively?
jurors. I did. I do think that was effective. I think that it definitely got its point across. No question about that.
Interesting, because that's a wholesale sort of departure from how the state had been handling this previously.
It was, but if you remember, Rick,
it's a Kelly Siegler type move.
I mean, she laid the precedent, right? Yeah. She did. She created a bar that now all prosecutors are trying to reach. And then it's up to the defense after that to come up with some kind of way to dispel that, which I think Rick DeToto did, because what he said was, turn the lights off.
Yeah.
Now turn off all the lights in here. What can you see? And so he then visualized his story for the jury as well. All of that sounds good with every light in this courtroom on, but let's make it as dark as it was on that fateful night.
Yeah.
And could he really see? And if he could, what could he see?
And the lights were then immediately turned off.
Yes.
All of the lights were turned off so the jurors and all of us in the gallery could see what, as DeToto's walking through us.
Let's talk about something else real quickly that I'm just trying to key in on the things I think will play a role in the jurors' minds as they're deliberating and thinking about things. And one of the things I think, if I were a juror, I'd have to square up in my mind is the alarm.com expert, the alarm data, the issue of whether or not ever it was possible or that anybody else got into that house after they set that alarm. Where do you guys stand on that? Who would you put the checkmark win by in terms of the alarm issue?
I say that's a difficult one.
It is.
It's a difficult one, and I think that's probably, I would assume, what the jurors will really be going back and forth a long time about, because both sides were effective. The prosecutors had this expert going through the whole alarm system saying it works just as fine, but the defense had the same witness admit that there were a number of rare occurrences that happened in this family alarm system that didn't show when the doors were opened or closed. So they admitted that there are these rare occurrences. So it's that, I think all of this will go down to what the jurors think about that alarm system.
Do you think that Toto successfully undermined the alarm data integrity, I guess, that it makes mistakes sometimes?
Absolutely he did. And then if you remember, he set this thing up in opening statements. Do you remember when he took that cardboard, I think it was like a fake witness, if you will, but the witness had no face, right? And he stuck that cardboard witness in the witness box. Yeah. And he said, let's pretend that this is the alarm system. And the alarm system is in fact a witness. Remember he said that? And he visualized that by putting that cardboard witness in that witness stand. And he says, now if this witness lied to you 77 times, would you believe it? Anything he has to say. And so he's going to carry that through closing arguments, I promise you, because he was able to get the alarm.com expert to say, yes, this alarm system was faulty. Yes, it made false reports. Yes, you could not tell whether or not it was the door or the garage door. So here you have a witness that's just not reliable 100% of the time and is able to lie, right, metaphorically. And so I do believe he kind of created some reasonable doubt as to whether or not that alarm system was absolutely working on that night, because that's what those jurors have to believe, that on that night, at that time, that alarm system was working without error. And you just really can't say that.
And we know with testimony from the defense bringing on when they had the case in their hand, Kira, the sister, testified that she was the one who set the alarm that night, kind of bringing a better picture to how all of this unfolded. And I think there is a juror member who works in technology. I'm sure the prosecutors may hope that individual can articulate how this system works, whatever way they may say, or the defense could say, well, have this juror say, well, there were some kinks in the alarm system itself. And at the top there, we have all those pictures from when the defense had this case. The family members are there. And in the center of this artwork here is Kay Winston, Antonio Armstrong Sr.'s mom. Yeah, crying. She was the second person.
AJ's grandma.
Yeah.
She is clearly in his corner, AJ's corner.
Absolutely.
And it was something you and I spoke about yesterday. As soon as she walked in, sat on the stand, she turned, faced the jury the entire time until there was a break. And I asked you, I was like, was that tactical?
Absolutely, it was tactical for two reasons. One, that's who she's talking to. She's talking to those jurors. She's not talking to us. She's really not talking to the lawyer. She's not talking to the judge. She's talking to those 12 people in that box. And when she turned to them, it was as if she was saying, listen to me. I have something to tell you. And I need to tell you about my family, my son, my grandson, and what happened on that night, and what I believe this child is capable of. And the only way that she could get that across is to look them in their eyes. We cannot forget that when we're dealing with trials, we're dealing with human beings. Right. And you trust people who will look you in the eye and tell you what they believe to be their truth.
So you think that Grandma resonated with the jury?
She absolutely did. She did.
Okay. Let's talk about a couple of other important sort of facets to the trial that we saw over the last, this is day 12, right?
Day 12.
This is day 12, and really the third week. Let's talk about the brother, Josh Armstrong, who kind of seemed like he could be an alternate suspect. At least that's how the defense laid it out. Certainly the state's case, prosecution, pointed us away from that. But what do you guys think about the introduction near the end of the trial of his medical records, I guess sort of his competency? because there's an argument of, you know, when he started to have mental health issues. Was it before his parents' death? Was it after his parents' death? Where does that stand, and where do you guys think that the brother stands in terms of in the minds of the jury?
So the prosecutors, they brought out 8 different hospital stays that Josh, AJ's older brother, went through 6 months after the murders. And this is what happened yesterday. They were trying to say that because the defense is arguing that there might have been religious delusions that Josh may have experienced, moments of it before the murders. But then they refer to the documents. Well, in the documents, it's no points mentioned. I think they said it's mentioned only once of any religious delusions that Josh may have experienced, and all of that was after the murders. But the defense was able to bring in a form that Josh went to Ben Taub ER. Actually, no, that was 6 months after again. That was 6 months after.
Yeah.
There were basically, the prosecutors are saying there was no point that showed any sign that Josh had any mental illnesses or was suffering from any of it until after the murders. And his girlfriend was testifying.
His girlfriend definitely corroborates that, right?
Yeah. Well, and I think that's when grandmother came in and said, well, no, that's not completely true. That he was having issues prior to, they just were not as severe. And so I think what the prosecution laid out, and I think they did a good job in doing so, was that the severity of his mental issues, when it was the suicidal ideations and all of those things, didn't happen until after the murder. And the defense came back and said, yeah, that may be true, but the guy wasn't completely there in the beginning in the first place. He had issues. He did things that were just really off the charts in terms of someone who has stable mental health. And so I think that it becomes a wash to me. It becomes what we call the battle of the experts. You're going to have the prosecution expert saying one thing and the defense expert saying exactly the opposite thing. So who do you believe, right? It becomes a wash. And the jurists normally will say, you know what, when you have 2 battling experts like that, we just remove that evidence off to the side and start looking to the other evidence to see if we can get there.
I thought it was pretty interesting that, you know, Josh Armstrong, I thought that Toto was effective at sort of showing that Josh Armstrong, I don't know, could have been sort of an alternate suspect. And also, tell me if I'm imagining this, but didn't at some point a doctor or clinician who examined Josh Armstrong say that he had said he witnessed the murders?
Absolutely. What he said was, in fact, yes, when I saw the murders or when I witnessed the murders of my parents. And so Rick DeToto harped on that and said, when you witnessed, why would someone use the word witness as opposed to when I arrived on the scene?
Right.
Or when I got there, when I got to the home after my parents were murdered. He actually said when I witnessed the murders. So that was something that I think that Rick DeToto harped on, and then he backed it up with the fact that there was just no investigation done into Josh.
Really wasn't?
At all. It wasn't. And so they never really ran that to the ground as to whether or not he could have been a suspect.
And then prosecutors tried to poke holes in that theory that he said he witnessed it, having their forensic psychiatrist experts saying, well, we don't know, that just might be a person at that point, his illness, any of all those issues. But they're alleging, prosecutors are saying rather, that Josh was at the scene and he saw his father being carted out by the ambulance at that point.
Yes.
And the lead, I think, homicide investigator from 7 years ago with HPD said, look, there was never, ever a reason for us to go outside of the house.
Right, exactly. And that's the way they felt about it, and that can go one way or another. I think most jurors, though, most of the time want investigations to be thorough and a double homicide. So it's going to be interesting, guys, as to what they come with in these closing arguments.
I know.
It really is. What is the prosecution going to say? What is the defense going to say? And I think if we can talk about that a little bit, I think that the state is going to harp on those text messages in terms of the phone log and when the light came on, when the light went off. And when I say text messages, one in particular I think that the prosecution would harp on is when mom says, Dawn, the mother, says to AJ, hey, AJ, the alarm system doesn't lie, but you do.
Right.
So I think that's key. Then they're going to talk about the timeline with the text messages, with the phone, when the light came on, what floor he was on he on the second floor, how long did it take from that movement before he actually called the police. The fact that the alarm did not go off, they're going to harp on that. And now that they brought in those stairs, they're definitely going to bring that up.
Tell me real quickly, the stairs are illustrating what? That there's no way he wouldn't have had a vantage point in to see what was going on, or what?
That's what prosecutors are alleging. They're saying that AJ couldn't have seen if that he did, they were showing that he was so close to this perpetrator, he would have got more out of it. That's what the staircase was showing, that the closeness to the parents' bedroom.
I mean, there is this mysterious perpetrator who AJ says was in the house, and then that person sort of disappears, right?
Correct.
We don't ever know or learn more about who that person is, and I guess the prosecution, the state, was sort of undermining his point with the stairs, right?
Yeah. They are.
Okay, so that's the prosecution. We got an idea. One of the things, by the way, that the producers want us to talk about is the relationship, how it's positioned AJ with his parents. Obviously, they've both got a different view, with the defense saying, look, this is an everyday teenager, he fights with his parents just like every other kid, and of course the prosecution says, oh no, it's a lot more sinister than that, look at these text messages. Is the interpretation of the texting between the parents and AJ going to play an important part in a juror's mind, do you think?
I think I don't know. The text messages, there was a lot of it that was presented in court. The way you referenced in how it was used with the alarm system and AJ's phone, I thought that was tactful. That worked for the prosecutors. But then the defense did bring in some text messages showing that the family was all right. This was a normal family. They were showing that Don and Antonio Sr. celebrating AJ's achievements and all of those things. So it just depends on what the jurors remember from the text messages, and it would be interesting if they ask for those evidence while they're deliberating. They're like, hey, can we see some of those text messages?
There were positive messages, positive exchanges between the parents.
And for me, guys, I'm sorry. This argument for the state just wholly fails for me.
Really?
It really does. And maybe because I'm a parent and I had a child who really tested the limits with me, and if they looked back through our text messages, I promise you it will be no different than what you saw with AJ and his parents. I've called my daughter a liar before. I told her she was full of crap before. I've done all of that.
You can't cuss on the internet.
Well, I didn't.
She did it.
I said crap, and I wanted to say something else. And I would tell her, you're pissing me off. I mean, so for you to go from that, you're going to take a leap that I'm having issues with my 16-year-old in this day and time, with social media, with weed smoking, with all the things that these teenagers are doing, that you're going to leap from that to a double homicide of your parents. That's just too much of a leap for me.
I wholeheartedly agree with
That's
that. I don't
much.
think the text messages are very sinister or anything out of the ordinary.
No.
A conversation with parents, the kids are kids.
Yeah, they're kids.
So we'll see where that goes with the jury. Let me see what else we got to talk about. Oh, how is it going to? Okay, so do we? We expect closing arguments are going to wrap up today, and they're going to get the case today?
Absolutely.
Yes.
Yeah, the jurors will get the case today.
Absolutely.
What time, we don't know. The judge thinks about 1 o'clock. It may be in the jury's hands. They will get that today.
Do we know the mechanics? So if they're being sequestered, do we have any idea how does this typically work?
So what will happen is they will work as late as they will allow them to work, okay? So most of the time, especially when they're being sequestered, they're going to go past 5 o'clock. So sometimes they'll deliberate until 6 or 7 o'clock. And now keep in mind that while a jury is deliberating, you as the defense attorney, you're stuck here. You can't go back to your office. You can't go handle other business. You're just waiting around the courtroom.
You can't go back to your office?
You cannot go back to your office because as the jurors are deliberating, they may have a question.
Oh, true.
And so if they have a question, the defense as well as the prosecution can determine how the judge should answer that question. So there's always some controversy there. So sometimes they will say, well, what did this witness say? Well, there's a particular way they have to ask that question before the judge can answer. So what do I mean by that? They have to point out the witness.
Yeah.
They have to point out whether or not it was on the prosecution side or the defense side.
Oh, wow.
And so then at that point, then the court reporter goes back and looks for this. then as a result of that, they both get together and decide whether or not that's a fair answer to that question.
This is a time-consuming process.
It is. So it's not just the jurors ask a question and the judge just answers it. No, it doesn't work that way. They have to get together and agree that the judge is answering the question properly, because the judge can never be believed to have commented on the evidence.
I count 8 juror notes that were sent in from the 2022, the second trial, and they ask things like they want to see the text messages again, they want to see the alarm.com info again, all the things that you think that they might key on.
Absolutely.
They want to see sort of, it looks like data and evidence in a lot of them. Sometimes jurors are asking to stop early because they have appointments. I can't remember if they were sequestered in the first 2 trials.
The second one, I believe they were, weren't they? Yes, I believe the second one they were.
And with the jury notes, I know we have a good story on Click to Houston, kind of going over some of those notes. There's a really good one on the website.
Yeah, it's really interesting how they come in. We don't have a lot of time, so we're not going to go through each and every note. But so, moving forward today, if you guys were guessing, I'm always asking you to speculate and guess. When do you think are they going to get the trial, get the case after lunch? Are they going to start deliberating then? Do we think?
I think she'll give them lunch.
Yes.
She'll give them lunch and then they'll start.
If they start at 9:30, she's probably got a few little housekeeping matters that she's going to take care of with other folks that are in her court that day. So let's say realistically they start about 9:45, 10. And so now we're at 10 o'clock. Let's say an hour and a half per side. Give a little leeway. So then you're talking about, what's that, 3 hours from 10? We're now at 1 o'clock. So they'll eat lunch and they'll start deliberating.
Wow.
So I'm thinking 1 o'clock, 1:30 the latest, they will get this case. They will get in 4 to 5 hours of deliberation today.
So we're just spitballing, but is there a possibility that they could come back with a verdict today?
Of course there's a possibility. I've had a 45-minute verdict before.
Really?
But not at a case like this.
Does long deliberation in favor of, I've always tried to sort this out. When they think about it longer, is that in the prosecution's favor? Is that in the defense's favor?
So there is a theory, right,
Okay.
that hangs around the courthouse. It's not absolute, but there is a theory. The longer the deliberation, the better it is for the defense. The shorter the deliberation, the better it is for the prosecution. Now, I just stated I had a 45-minute verdict, but that was for a not guilty. Much different case than what we're dealing with here. There's just too much evidence for us to get a 45-minute verdict here. It's just, I think that jurors, and you'll find this, believe it or not, jurors are very deliberate. They take their responsibility very seriously. They take the fact that they have this young man's life in their hands very seriously, and they are going to go through all the evidence. 9 times out of 10, when they first get back there, they're going to take a vote.
Well, right off the bat?
Right off the bat.
To see the gauge of things.
Just to see where things are. And normally no one is, rarely are they all on the same side. And even if they are on the same side, even if they're unanimous, they're going to say, well, let's walk through this and make sure we're doing the right thing. So, and then they'll periodically take votes.
Is that when, will the alternate jurors be in conversation with them?
No.
Or they put a different room?
Yeah, what
are
are they
with
doing?
them,
What
just
are the
quiet?
alternate 3 now? What are they going to be
They
doing?
are off to another room somewhere with a book or a laptop doing their own thing, not researching the case though,
Really?
but they're doing their own thing, waiting to see if they will be needed. But they are not allowed in that jury room while the jury is deliberating.
Boy, it is going to be a big day, and it all gets started, we think, 9:30. Closing arguments about to begin this morning, something that we've been waiting for, really, if you think about it, 7 years, because the crime took place in July of 2019, but this is certainly a big day. 16, yeah, sorry, 2016, that is 7 years. And it all gets started here in just about 1 hour, we believe. This could go to the jury today, and we'll leave it at that. We won't speculate beyond that, but certainly a big day in AJ Armstrong's 3rd murder trial. Let's send it back to you guys in the studio.
Joel, we will be waiting. We will be watching. A lot of information and really great conversation. Thank you all. You still have a couple of hours to dive deep into this case. If you scan this QR code on your screen, you will get a day-by-day breakdown of the trial, plus what the legal jargon means.